Welcome to Looking at Legal Stuff. Today we have 14 hearings covering several different motions for contempt, with a mother who is refusing to follow prior orders of the court, including not providing the driver's license and insurance info of anyone driving the child if requested. She was ordered to remove an inappropriate TikTok account that Mom let the child make, and most concerning of all, the child is not supposed to be introduced to any new boyfriends for the first 6 months, but not only has the child seen them kissing, but the new boyfriend has a laundry list of recent criminal charges that has the gal very alarmed. Let's see what the commissioner thinks.
Requesting a seto.
Yes.
I think I heard Carissa Shoemate.
Yes.
Okay, let me, that is number one on the docket. Is Kyle Weiss here?
Yes, I am.
Okay. Ms. Shoemate, go ahead. Why are you requesting a set over?
I didn't get a chance to give Kyle my response.
Okay. Mr. Weiss, any response to Ms. Shoemate's request for a set over?
Yes, Your Honor. According to the records of the sheriff's office, she was served on February 6th. She's had plenty of time to serve me, and every time we end up in this situation, she always asks for a continuance. I'm ready to proceed today. She's had plenty of time. She was served on the 6th. That's about 2 weeks.
And if I may weigh in, Your Honor, this is Beth Fellows, the GAL.
Yes.
I would not served any paperwork from either side.
Okay.
It's my understanding Beth Fellows is no longer on our case. I didn't believe she had to be served.
Have you been dismissed on the case?
No,
Ms.
Your
Fellows?
Honor. I'm still listed.
Then
All
that's
right.
my mistake. That's my mistake then, Your Honor.
Okay. All right. Ms. Shoemate, you were served on the 6th. That does give you plenty of time to respond. And I know you did file a declaration that I reviewed. However, because Ms. Fellows was not copied with anything, I think a 1 week set over makes sense. And I'm requiring that both parties today send their paperwork to Ms. Fellows so she can review it. Okay. All right.
They
So
can send it via email.
that would be fine to do that. So on Weiss versus Shoemate, then we'll put that over also to March 1st.
Thank you.
And given the allegations and that I need to hear from everyone, I'm ordering that there not be any visitation between now and then. I don't know if it falls on the regular schedule, but I want the visitation suspended at this point. Okay.
Okay, and what time would that be on March 1st?
Thank you. That's a good question. It'll be 9 o'clock, just like today.
Okay.
And on Zoom, just like today.
Okay,
Okay. Thank you.
thank you.
Kyle Weiss and Carissa Shoemate.
Here.
Shoemate's here. Is Kyle Weiss here?
Yes, present.
All right. Good morning. Mr. Weiss, I believe this is your motion for contempt. And so why don't you go ahead and present your case?
Is the GAL assigned to our case Beth Fellows present?
I haven't seen her yet. If she's important to your case, then we can pass it and go on to the next one.
I believe she is. This is why we set it over from last week. She had some input on it, but yeah, I believe she's important to the case.
All right. I don't see her and she's not in the waiting room. So let's pass it. Let me just check sometimes I get an email about that. But I don't see anything. So, all right, we'll pass it for the moment. Thank you. When I see her log on, then I'll come back to the case. Okay.
Sounds good.
Okay. Let's go back to Kyle Weiss and versus Shoemate. I think this fellow is with us now.
Yes, Your Honor. Thank you.
Sure. All right, Mr. Weiss, you're here.
Yes, I am.
All right, there you go. I wanted to make sure you unmuted yourself. All right, again, it's your motion for contempt. So if you want to go ahead and argue that, and then I'll hear from Ms. Shoemate, and then I'll hear from Ms. Fellows after that.
Alrighty. So, me and Miss Shoemate have an existing order, and some of the motions in that order are Taylor's social media accounts were to be removed off of the internet. That was 15 months ago. They're still up. Another one is Taylor was not supposed to be introduced into any men, any new lovers until they have been dating for at least 6 months. What was the other one I was doing here? When Taylor's being transported for drop-offs, if somebody that is unknown to me is transporting her, that is driving, I am allowed to ask for insurance and valid driver's license. This happened on December 25th at a drop-off. I requested it. Miss Shoemate denied me that ability. Her initial response was, and this is through text message, I do not have to provide that to you. And then she provides a statement to the court that says, oh, he wasn't comfortable with giving it. So she gave two different stories. Let's see, going through my notes here 1 second. As far as the social media goes, there's a very inappropriate video of my child that's been on the internet for quite some time now that she was told to remove. And it is a video of my daughter when she was younger twerking on a camera with material stuffed in her butt to make her butt look bigger. And she was unsupervised making this video. And then as far as the new boyfriend, on December 25th, when I pulled up to pick up my daughter, Carissa Shoemate denies that that's her boyfriend, but I saw those two smooching as I pulled up. So I began taking pictures. Taylor has informed me that she sees kiss and smooch all the time. Miss Shoemate spends a lot of time with Vince. Every time she calls to speak to her daughter, she's at Vince's house. And then there's a picture of Carissa's Facebook. She's in Vince's bedroom wearing his clothes. So she thinks she found a loophole of, oh, we're just going to say we're not together, and then we avoid it. I don't think that's okay at all. And I believe those three matters were it on the contempt.
What social media site is this video on?
TikTok.
Okay.
Taylor has her own TikTok account, and it still exists. She also had an Instagram. I don't believe she had Facebook, but she was ordered to remove those, and it's been at least 14 months now. They have not been removed.
Okay, thank you. Ms. Shoemate, do you have a response?
What was that?
If you would like to respond, you can do that.
Yes. Vince is somebody, we're taking it slow, so we're just being friends. And the TikTok and the Instagram, I tried to remove, but I no longer have that number, so I can't. I'm trying to figure out how to remove them. and I've never kissed my Vince in front of my daughter at all.
Would your daughter be able to remove it since it's her account?
Well, I'm the one that helped her and used my number. So it was an old number, so I'm trying to figure out how to go around that.
All right. What about the failure to provide the insurance and the driver's information?
He said that he will provide it to you guys. He didn't feel comfortable giving it to Kyle
Why was that?
because he doesn't know him, and it has all his personal information on it.
Your Honor, can I address that?
Not right now.
Sounds good.
There is a requirement, however, that anybody that drives that Mr. Weiss can obtain that information. Do you agree with that?
Yeah, I seen it when he sent it to me.
Okay. Anything else?
Nope.
Okay. Ms. Fellows?
Yes, Your Honor. I haven't really been involved in this case since December of 2021. I did file a report, and the court did agree with my recommendations to change the custody to the father. So I don't know a lot about what's going on except what has been filed. What I can say is that it has been concern about mom moving frequently. Excuse me, and she has moved again from the place where I knew that she was up in Rochester. She said to me when I asked her that she moved about 10 months ago. So she is in the local area, in the Longview area right now. The boyfriend, Vince, that has also been a concern throughout the time that I've been involved, is that she does get involved with different males, moves in with them, then breaks up because she was living in Rochester with her boyfriend, Reggie, and his mom. I don't know why things broke apart there, but now she's with this Vince. To be honest, with the history that I know, I would find it very disingenuous to say that she's taking it slow, because generally she jumps in and moves in and is in a relationship very quickly. And it does say that she's supposed to wait 6 months before introducing any kind of love interest or anything of that sort to Taylor. So the fact that Taylor knows about Vince is said, that she's seen her mom and Vince kiss and things like that leads me to believe that there's more to this relationship. The social media, that is a concern. Not sure why mom can't be able to shut those down.
All right. Mr. Weiss, you have the last word if you want.
Yes.
Go ahead.
As far as Vince goes, I have a pretty good idea, and I got some information that I will provide. I just found this out recently. I believe she did not provide the driver's license because at that time, Vince had active warrants for his arrest. Since our court date last week, he has been arrested twice and currently has 11 pending charges, including domestic violence and threatening to kill somebody. I don't want this man around my daughter at all. I'm pretty sure Carissa Schumann is aware of this situation and still has intentions of bringing him around my daughter. I want something done about it if we can. As far as the social media, if Carissa had shown or proven some type of evidence she tried, like she had texted me and said she tried, or she got a hold of somebody and said she's trying, she can't figure it out, I think that'd be a little more believable. But I've seen no effort as far as evidence goes, as she's been trying to remove them. She knew she was supposed to remove them, and there's just been no effort. That's all I got to say.
All right, thank you.
Your Honor, I would like to ask, what is Vince's last name?
Shoemate, do you know that answer?
Taylor.
Vincent Taylor?
Yes.
Okay, Mr. Weiss has brought forth 3 potential reasons that Ms. Shoemate is in contempt. One is that their child was in a vehicle driven by someone. He asked for the name of the person and proof of insurance, and also their driver's license number, which is was provided for in a previous order. Through text messages, that was not provided. It's insufficient to say, well, he'll provide that to the court now. The purpose of that order was to allow the father to confirm that the daughter is in a car that honestly is fully insured. Accidents happen. If she's in a car that's uninsured, that's in an accident with an uninsured car, she could have damages that will never be compensated. I think it's a fair request to make sure that she is transported in a vehicle with full insurance. So the answer to that at this point is inadequate. The second is that the social media, TikTok, did not remove this particular video. That also was required by the court. Ms. Shoemate indicates that she isn't sure how to do that. For now, I'm going to accept that. I'm going to put this over 1 month on that issue only. If that video is not taken down within a month, then I'm going to require that the daughter not have a TikTok account. She'll have to close her account. So if she wants to keep her TikTok account open, the mother and the daughter are going to have to figure out how to remove that video. Third, there was an order that any new romantic interests would have to last for 6 months before the daughter would be introduced to them. There really was no response to that by Ms. Shoemate, and it leads me to believe that that provision is also violated. Let me just say, Mr. Weiss indicated a number of concerns about this person. I don't believe I can address those right now. However, you may consider bringing a motion for a protection order in a protection order docket if you feel that he provides it or creates a danger for the daughter. Based on 1 and 3 that I've mentioned, I do find that Ms. Shoemate is in contempt. I am required to assess a $100 contempt penalty, and that's what I'm going to assess. I'm going to require that she abide by those requirements going forward. And again, we'll come back and review the social media issue in a month. So today's the 1st. We'll come back here on April 5th.
Your Honor.
At 9 o'clock. Just a moment. To review that issue. Who spoke?
That was me, Your Honor, the GAL. Is Vincent Taylor's middle name Ray?
Yes.
He has a number of charges in Skamania County from November of 2022, stalking, telephone harassment, cyber harassment, harassment, threatened to kill, bodily harm. I'm looking at Odyssey right now. This is extremely concerning. I'm not sure what the court can do, except that I would like to have a little bit more time to research this to see where the cases are. But if this is indeed the boyfriend that the mother has, there should be absolutely no contact between the child and the mother, or the child and the boyfriend.
Okay. All right, well, let's set a review then for next week on March 8th. I'm also going to leave the April 5th date to review that issue.
Okay.
Let me ask, Mr. Weiss has also filed a number of proposed orders dealing with a temporary family law order, a parenting plan, and child support orders. Ms. Shoemate, have you had a chance to review those?
I've gotten through some of it, yes.
Are you going to object to any part of those orders?
Yes, I didn't know if I was supposed to file anything.
Okay. So since we're coming back next week, and since the information Ms. Fellows may find out may affect how I address the proposed parenting plan, if you want to file a response to those proposed orders, please do that by Friday of this week. And then we'll address all of those orders next week. In the meantime, between now and next Wednesday, I'm ordering that there be no contact with Vince Taylor, between the child and Vince Taylor.
Okay.
Okay.
Your Honor.
Am I able to leave her?
Say that just a little bit louder.
I have my weekends with her.
As long as Mr. Taylor is not around, if this is your weekend, you can have your weekend.
Okay.
Okay. If I hear that Mr. Taylor is around, that is going to have a significant impact going forward. So I just want to caution you about that.
Okay.
Okay. All right. So let's all be back here then on March 8th, and we'll take up the other orders and the additional information that Ms. Fellows has just discussed. Okay.
Okay. Thank you, Your Honor.
All right. Thank you. And I'm going to sign a contempt order with changing. Mr. Weiss initially put an amount of the penalty at $500. I'm changing it to $100.
Two more things real quick, Your Honor, if I may.
Let me sign this order first, and then
Yeah, sure. Sorry.
I will. Just a moment. Okay, Mr. Weiss, go ahead.
So for next week, we'll be able to address the child support motion and the parenting plan motion.
Yes, I want to give Ms. Shoemate an opportunity to file a response if she wants to.
Okay, and I don't recall, did you mention a time for next Wednesday?
It's 9 o'clock, just like today.
Got ya.
And it'll be on Zoom, just like today.
Thank you.
Okay, thank you. Ms. Fellows here. There we go.
Yes, Your Honor.
Is Mr. Weiss here?
Yes.
All right, great. Thank you. We put this over a week so Ms. Fellows could do additional research into Vince Ray Taylor. And so Ms. Fellows, I'll turn it over.
I misunderstood. The first time that was asked, I misunderstood the question because I didn't know what LNI was. Because it was in Idaho and they just called it workman's.
Whoever's speaking needs to
in
mute
Idaho.
themselves.
So,
I'll do this.
okay.
It's difficult to tell. All right, Ms. Fellows, go ahead.
Yes. Yes, Your Honor. I did reach out to Skamania County
There was a back
Prosecutor's
one.
Office.
Yeah.
And they did forward me the motion and affidavit for issuance of a bench warrant, which basically is a probable cause statement. It is, looks like
Deal.
there's a number of pages to this probable cause. I also got amended information about the charging information. There are 11 charges. They are telephone harassment, threats to kill.
I mean, I'm maybe my back does
I'm
hurt
getting
sometimes, but
some-
it could just be because I'm older now. But it doesn't impact my life really that much. Mhm.
Is that coming from?
Somebody's on our screen that's talking. There's not anybody talking to your background, Ms. Fellows?
No.
I did. I was employed at a grocery store and slipped on a grape in the beer aisle of all places. Yeah, one grape and pulled all the hamstrings in my leg.
It's
in my
not
right
on.
leg. And my case was handled with a little bit of difficulty. I was a little upset with L&I because they harassed
We
me
got a
at
phone
home.
call in here. We can't figure it out.
And when my doctor told me not to work, they kept insisting I could go to do something. I could put my foot up on a desk or something and answer the phone. But that's not what my doctor told me to do. So I was a little irritated with them, with L&I. So, but I did get my case settled and I was medically taken care of. I didn't go to court or anything. It was just settled with
The only thing
them.
I think it
You might
was.
need to exit your,
Come
you
back.
might need to exit your honor and come back in.
Yeah, and everyone, we've got this additional noise going on. So I apologize for this. I'm going to end this meeting, which means you'll all
Pulled
have
the
to log
hamstrings
back
in my leg.
Okay.
And
then
yeah,
hopefully we can
I did
take
like
care
the
of it.
German splits.
All right. Thank you for everybody's patience. We had some interesting technical issues. Let's go back to the case of Weiss versus Shoemaker. Ms. Fellows,
Your Honor.
you were indicating you had checked with, I guess, Skamania County.
Yes, Skamania County Prosecutor's Office, and they did get me some documentation. This is regarding Vincent's former girlfriend. They were in a dating relationship for about 4 or 5 months, it sounds like. They were arguing in the car. She was driving on the freeway. He apparently tried to stop the car by throwing it into park. She ended the relationship at that point in time. That was October 12th of 2022. And then there are allegations about him cyber stalking and things like that. So out of that, there are 11 charges. Telephone harassment, threats to kill. This also has to do with his ex-girlfriend's, a friend of hers. So it was telephone harassment, threats to kill to the friend. And in the probable cause statement, it says that Vincent had threatened to slit the daughter's neck. So that is the friend, the male friend of the girlfriend, threatened to kill daughter's throat and his mother's neck, making the friend watch them bleed out. Very significant concern. Count 2, telephone harassment. Again, that's the friend. Harassment, threats to kill. Again, that's the friend. Cyber harassment, that's the friend. Stalking, first offense, that is the friend again. Then we go, count 6 is telephone harassment, domestic violence, that's the ex-girlfriend. Harassment, first offense, domestic violence, ex-girlfriend. Cyber harassment, domestic violence, that's the girlfriend. We have stalking, first offense, DV, girlfriend. Identity theft, second degree, DV, girlfriend, ex-girlfriend. And the last one is attempted theft in the third degree, domestic violence. So those are very significant charges. It is still, there hasn't been any resolution at this point in time. So I have very significant concerns about this person being anywhere around Taylor. I do have concerns that the mother has gotten into this relationship. It sounds like she was starting this relationship when Vincent was doing these things. It's just a very significant concern given the past that I know of mom getting into relationships, having Taylor around various men, moving in with them, living with them, and then moving out. So at this point in time, given that past history, I'm actually recommending that any time that the mother have with Taylor would be professionally supervised visits, because I have no confidence at this point in time that the mother, Carissa, recognizes the danger that Vincent poses to both herself and her daughter. I don't feel confident that she would follow a court order. She hasn't followed the court's order about providing information about her address. There's just a lot of concerns, Your Honor. So at this point in time, that is my recommendation, and that any professionally supervised visits she would be responsible for payment, and that it be close to where the father lives with the daughter, which is in, I believe, Canby, Oregon.
All right, thank you. Mr. Weiss, any comment?
Yeah, I strongly agree with Beth Fellows' recommendation. That is also my recommendation. There's nothing standing that will show that Ms. Shoemate will even be honest about him being around. There's concerns about where she's actually living right now as well. She's been dishonest about that in the past as well. So, and hearing what Ms. Fellows said about Vincent, I don't want that man around our child, period. And I do not trust her to be honest about him being around either. I strongly agree with Beth on this one.
All right, where's Taylor right now?
Taylor is in my custody, and she is currently in school.
Okay. Ms. Shoemate, any comment on what's been discussed?
Yeah, I haven't lied about where I've lived. I've told Kyle everywhere I've lived. I live with my roommate who I've been friends with since 6th grade. And I only had Taylor around Vincent when I had car troubles.
Not true. You showed up with him on Christmas. I have pictures.
Exactly, because I had car troubles and it was snowing and that rain frozen wing rehab. I didn't want to cause, my tires are bad and I didn't want to cause a car accident.
All right. The pending charges against Vince Taylor are significant. And should Taylor and Vince Taylor ever be together, it seems to the court that could be a threat to Taylor, and the court's primary responsibility, I think, is to keep children safe. I don't think an order that simply says that Vince Taylor will not see Taylor, or Vince will not see Taylor, is going to be sufficient in this case. So at this point, I am going to order professionally supervised visits for the mother, so we make sure that the child stays safe. That may not be but for right now, I think we need to do that to make sure the relationship between the mother and child is okay, and make sure the child is probably those will need to occur at, well, I'm throwing out something, but I know Parents Place in Longview will provide that. The parties could pick another location if they want. Mr. Weiss, you will need to cooperate to bringing the child to these visits once they're set up. All right. So I'm going to order supervised visits paid for by Ms. Shoemate. Mr. Weiss needs to cooperate. I think we should set a review in about 4 weeks. And I'm actually going to be gone that week. So let's set a review for April 12th to see if those have been set up and see how they're going at that time.
Your Honor, if I may.
Yes.
Since the father and child live quite a distance away, the child being transported for these visits, it's not really in the best interest for that. So if the visits could be even in the Clackamas area, so that's closer to dad, that would be more beneficial for the child.
If then I'm going to put that burden on the father. Then if you can find a location near where you live for the supervised visits, then go ahead and do that. Again, though, Ms. Shoemate will be responsible for the expense of that.
I understand.
Okay. All right. I hope that can get set up, and then we'll see everybody back here on April 12th to check in on how that's going.
Your Honor, I've
Thank
got 2 more motions that I filed for that I thought we were going to work on, or 1 more motion that I thought we were going to do today.
Okay. I'm sorry if I missed that. Which motion was that?
The child support motion.
Well, I will tell you right now, I don't think I'm prepared to go forward on that. And I apologize that that was supposed to be heard today. I will make a note and we'll take that up on April 12th. Okay.
Copy.
Okay. All right. Thank you. And we'll see you back here then.
I am going to next call another matter where we have a GAL present. That's number 2 on our docket. 1730000404. Kyle, is it Weiss?
That's correct.
Okay. And then we also have Carissa Shoemate. I saw you log in. You are present.
Yes.
Okay. And then we have Beth Fellows, I believe, as the GAL on this matter.
Yes, Your Honor.
Perfect. Thank you for being here. I somehow have lost some folks. Okay, I see Ms. Shoemate. Ms. Shoemate, do you have video capabilities to turn on?
I do.
Okay. And then Mr. Weeks, are you able to turn on video? Or did I lose you?
No, I'm still here. Yeah, I can go on video.
Here you are on the Samsung. Okay. Did you say that you were turning on video, sir?
That is correct.
Okay. I haven't seen it come on yet, so we'll hang tight for a minute. Okay.
Is that better?
Yes, thank you. So you are Kyle Weeks, and we have Chris Shoemate here. So again, I'm kind of getting up to speed as the commissioner filling in today, what I believe we are here for. There's several things happening in this case, but what I see today's hearing is for is a contempt review. Is that the understanding of the parties?
I just got the documentation yesterday, so I haven't really got the chance to read all of it.
And Ms. Shoemate, which documentation are you referring to?
The contempt.
Okay. Well, so help me understand that a little bit, because my understanding is you all were already here where Commissioner Nelson made some rulings on contempt and specifically gave you some deadlines for things like removing videos from TikTok of the minor child. So help me understand what you mean when you say you just got documentation.
I got, he served me more papers.
Let me grab what I have on this case. Are you, I have amended contempt hearing orders. Oh, they did. Okay. Oh, that's not on for today. Okay. Okay. So the clerk is helping me understand a little bit more. It looks like more recently, as of just a couple days ago, there on April 3rd, so 2 days ago, had about almost 40 pages of affidavits filed. And then Mr. Weiss, I'll also say I did get a USB drive from you that purports to be, I think, the seatbelt issues. Maybe, Ms. Fellows, were you able, did that go to you also? Because
yes, it did.
It did. Were you able to open it and review it?
Yes.
Oh, I may need to rely on your review a bit. I tried last night, so they don't let us put these into the court computers. So I had to take it back to my private office and review it there. And it kept saying that the program wasn't accessible and it would not let me review it. So I will let the parties know while I have this USB, it is not something that I've been able to review, but I have reviewed the pleadings. I've reviewed Commissioner Nelson's prior contempt rulings in this case. And I did review the April 3rd filings because I thought that was something we were discussing today. It looks like there's an overlay where I think those additional filings are discussing the prior contempt rulings and some responses and potentially some new information. Ms. Fellows, I think I might go out of order here and turn it over to you first to help me make sense of any recommendations you have for how we're proceeding today.
I will try. I believe that, let's see, we were in court on March 8th. That was basically a review of Vincent Taylor, who is the significant other of Miss Shoemate, since there are extremely concerning criminal charges that he's facing in Skamania County. So at that time, it was ordered, it was recommended, I recommended, and it was ordered that the mother have professionally supervised visits, that it was to be in the local area where the child lives, which is in like the Clackamas, Oregon area. And the father was to find a place and let the mom know, and then hopefully that there would be supervised visits set up, and there would have been a couple of visits from that point until this court hearing. So I think that's what this review was set for. There was also the contempt charges and things like that that were to be basically amended. And it was, the court did want the father to give more specific information. And he did provide that. And then I did get that video for the seatbelt because that was an issue. So that's kind of what we're here for.
Okay. So let me start with the parties, maybe on something that I would think might have a yes or no answer, but I'm guessing doesn't. And so I'll start with you, Mr. Derby, or excuse me, Mr. Weiss, throw back to the prior case. Mr. Weiss, are you aware of whether the TikTok video you were concerned about has been removed?
I am aware that it is still posted as of today. It has not been removed.
Okay. So Ms. Shoemate, the court was very specific based on my review of Commissioner Nelson's notes that that was to be removed by today's date, that you've already been found in contempt for having it up, and that we were giving you this additional time to remove it.
And it has been removed. I don't know what video he's talking about, because I went through and erased any videos that could go as inappropriate for her age at all. And I went through and erased it. I had my sister help me.
Okay, so I guess the court's in a little bit of a bind because I have one party saying it's still up, another saying that it's been removed. Someone help me out here with some actual evidence of whether this, and I think the video that Commissioner Nelson issued a contempt on was a very specific video involving the child. And I can pull up his notes and give the parties more information on that.
I believe that the ruling was that the social media accounts were to be taken down, not just a specific video, but that any of social media accounts were to be taken down, period, end of story.
And I do think that is much more clear. So Ms. Shoemate, where are we at with the social media accounts of the minor child?
I did try to delete the TikTok, but I no longer have that number that's associated with it.
Well, hold on. You made that argument last time you were in front of Commissioner Nelson, and you were given specific, I guess there was a lot of discussion about how that probably is not a very accurate answer. So let's start over and tell me why the social media accounts are not deleted. There's always a way to go in and delete an account. You can recover a password. You can.
I got through. I finally got on her account with the password, but I tried to delete it, and it wants my old number where I no longer have, because it sends a code.
Have you reached out to customer service? Have you made any further attempts besides just, well, it doesn't work?
I've been trying to find the customer service on how to contact.
Okay, so what I'm going to do is find that you're still in contempt of court with regard to the social media accounts. We'll give you another 30 days, and at the end of today's docket, we'll find a new date depending on how many issues we need to discuss. But this will be your second contempt finding with regard to social media accounts of the minor child. And I will make a ruling to that effect. The next issue, I believe that Commissioner Nelson wanted some additional information on. I'm just going back to his notes. I believe, was it that he wanted additional information on the seatbelt issue? Is that why the USB was provided?
Yes, I believe so.
Okay. Mr. Weiss, how are you wanting to move forward on your request for contempt regarding the properly fitted seatbelt issue? Mr. Weiss, if you're trying to speak, you're muted. I can't hear you. Mr. Weiss, are you still with us?
I am. Can you hear me?
I can hear you now.
If we can get the situation addressed in this court hearing today, that would be awesome.
Okay. So help me understand just a little bit. And again, I know it's a somewhat difficult position since I didn't hear the original contempt, but the notes I'm showing state 3 contempt issues. So this was from your last hearing on March 1st. Court addresses parties. There's 3 contempt issues. Driver refusing to provide required info, social media not being removed. Court accepts unable to remove for now, set over 1 month for that issue only. If not removed, daughter needs to delete account. And then there was also, the court did find contempt regarding the unknown driver information and exposure to romantic interest and issued the $100 contempt penalty. So it sounds like, even though I don't think there was an explicit ruling on the contempt for the seatbelt issue. Does that sound correct to the parties?
That is
Yeah.
correct. I had brought 5 contempts on that hearing, and we were only able to address 3 of them. So we're trying to get to the other ones that weren't addressed.
Okay. So I have some amended orders here. I'm just going to see if they specifically relate. Okay, there's the booster seat. I'm going to see if one of these is this. Okay, so I do have the social media contempt order that I will be signing. So let's move on then to this. The next one I have in front of me is the seatbelt issue. And let me first turn it over to Ms. Fellow, since you were actually able to review that video and give me some input. I have read the filings. I've read Mr. Weiss's attachments where he's citing seatbelt laws and what he thinks didn't comply with seatbelt laws. But Ms. Fellows, I'll turn it over to you.
Yes, Your Honor. I was able to view the jump drive, and it is clearly Taylor, and she is in the car, and the seatbelt is right directly across this way. So it's across her neck, and you can tell that the car is moving because you can see her kind of moving like this, like the car. And the seatbelt is absolutely right there. She does not look like she's slouching or anything else. It is absolutely a definite concern that the seatbelt was not positioned correctly, not even remotely correctly.
Ms. Shumate, any response to that?
She does slouch. She doesn't like sitting straight, especially going on long drives. She doesn't like to sit up straight. I'm constantly telling her sit up.
So what I did find in this case is that specifically the court has required that seatbelts be properly fitted. This is a huge safety issue for kiddos. Tons of research on this, tons of studies. I will find, based on the documents I reviewed, Mr. Weiss, as well as, not sure who's making all that noise. Mr. Weiss, I'm gonna mute you because I think that's coming from your end. Yep, it was. Okay. I will find that this is while seemingly I can understand, folks may see this as a minor issue. I do think it is a big safety concern, that we really are dealing with things that directly impact the health, safety, and welfare of a child. I will order contempt on that issue as well, given the evidence I've reviewed by way of documentation, based on Mr. Weiss's testimony and based on Ms. Fellow's statements as to what she was able to observe on the jump drive, even though I was not able to access it. So that will be a separate $100 civil penalty in addition to the prior contempt. And Mr. Weiss, I'll note for the record, I think in the social media contempt order, you had added the $65 for service of contempt. And I will include that in the contempt order. I do think that's a valid cost. Then we're going to move on to the third order I have in front of me was Taylor Weiss was left alone with Vincent Taylor during Christmas break of 2022, allegedly in violation of a court order stating child is not to be left alone with any male except father at any time. And Ms. Fellows, to the best of your understanding, I don't see that this is one of the contempts that Commissioner Nelson specifically ruled on. I think he discussed perhaps bringing a restraining order instead if there were these types of concerns, but I'll turn it over to you to provide some clarification if you're able.
I really don't have any clarification on Taylor being left with any other male. I know that there's concerns about it, but I don't have anything solid enough to be able to stand on to say that this did indeed happen or not.
Ms. Shoemate, are you able to advise the court under penalty of perjury whether you've left the child alone with Mr. Taylor?
No, she has not been left alone with him. He did come help me a couple times with my car issues, and that was it. She was never left alone.
Mr. Weiss, is there any additional? I did again review the pleadings you provided where you state that you believe this has occurred. Do you have any additional evidence for the court?
Other than the accuracy of what my child had told me and everything I was able to find out was accurate, no, all I have is what I provided.
Okay. I think more probably than not, I cannot find that this issue rises to the level of contempt, as I can't, again, more probably than not substantiate that it occurred. So I will deny the contempt order as it relates solely to the issue of whether the child was left alone with Mr. Taylor. So that one will be denied. Okay, so we've got those three issues out of the way. I'd like to let me go back to the calendar, see when you folks are back in front of this court on any other issues.
I believe we're due back next week on the 12th.
I see that. Okay, I see that now. Thank you. So there's a review for April 12th, 2023. And it looks like that one, at least according to Commissioner Nelson's notes, and the parties can correct me if I'm wrong, that at that review, the court will be reviewing the professionally supervised visitation for the mother and whether that has occurred. Does that sound correct to the parties?
Yes.
Yes, on top of child support.
Okay. So I'll just so the record's clear, next week we will have the court review those two issues. And then what I'd like to do is set you all out 30 days for a continued contempt hearing on whether the social media accounts have been deleted. Ms. Shoemate, it's my strong suggestion that you reach out to the companies if you're not able to get into the accounts. Certainly letting them know that there's a family law case pending and these accounts must be deleted. If there's an order from the court that is needed, we can get that for you, but I do want you to reach out to those companies and get that done. I show 30 days out as our May 3 docket. Does that work for you, Ms. Fellows?
Yes, it does, Your Honor.
Okay. And does that work for the parties, Ms. Shoemate, Mr. Weiss?
Yes.
It does.
So we're going to set you to May 3 at 9 a.m. And on that date, again, so the notes are clear, we'll specifically be reviewing any follow-up on the social media deletion contempt issue. Anything else from the parties today that we need to review?
No.
No, not on my end.
Okay. Stick with me just for a minute as I review the drafted contempt orders and find them in case I have any questions for the parties, okay? So there'll be a little bit of silence, but don't log off just yet. And Ms. Shoemate, there's a section specifically as it relates to the contempt on the seatbelt issue where it asks the court to determine if you're able to follow the orders now, meaning moving forward. So can you let this court know if you have plans to accurately fit the seatbelt moving forward?
Yes.
Okay. So I am going to find that you are willing and able to follow the parenting plan moving forward. And there is, if you need resources for properly fitting seatbelts, obviously, I believe fire departments still do that. There's lots of resources online, YouTube, those sorts of things. Okay, and then I'm not going to put a review date on the specific allegation of the seatbelt issue. It is my sincere hope that Ms. Shoemate will correct that. Obviously, Mr. Weiss, you could bring a new contempt motion should that not occur. So I've signed that order and it does require a $100 civil penalty for the contempt. And then on the social media order, that one will be $100 civil penalty plus the $65 for service of documents. Right now, I am going to find that you are still not in compliance, so not able and willing to follow the orders of social media. We're going to set, this one's going to have a different review date. Instead of no review date, we are going to review this on May 3rd, 2023 at 9 a.m. Okay. All right, so we've got that review date set solely on the social media issued. And then let me ask the court on the contempt hearing on the denied issue. Do you need a specific denial? If I just kind of cross it out and write denied, perfect. Okay. All right, and you want me to sign the denial? Yes. Okay. Yes.
This one, I just need a box checked here, so we don't.
Oh, perfect.
And then this one, there will be no judgment entered if there are not parties entered. And,
Perfect. I will do that. Thank you for catching that. And then this one, I'll need to click review hearing also, correct? Okay. Okay. You want me to check clerk's action on the denied? No. Okay. There you go. Here's your whiteout back too. I don't steal it. I've been known to run off with people's pens and other things. Okay, there's nothing else from the parties on this case. I have those 3 orders finalized. And the parties will be back next week, it sounds like, for a review on the child support and visitation issues, and then back on May 3rd for follow-up on social media deletion. Okay?
Okay, sounds good. Thank you, Your Honor.
Thank you. Thank you for being here. All right, you are free to log off.
All right, good morning. We're here on the self-represented family law docket A. I'm Commissioner Dave Nelson. I apologize for the late start this morning. The first case, let's call Kyle Weiss and Carissa Shoemate. I saw Miss Shoemate, I believe, there.
Yes.
Is Kyle Weiss here?
I am.
Okay. All right, I saw that there were a number of contempt motions brought, and I think they're set for May 3rd. And so we'll handle those issues on May 3rd. Today is to look at how the supervised visits are going and then to address child support. Why don't I go to Ms. Fellows to see what information she has, and then I'll hear from the parties.
Yes, Your Honor. My information is that the supervised visits have not started. The father did reach out to me to ask some questions about supervised visits. He did look into the community. He actually got quite a large spreadsheet of different agencies that are in his area in the Clackamas, Oregon. And he had found one. I looked at the website, looked really good and appropriate. He gave the information to mom. Apparently mom has not responded. I did try to reach out to mom myself via email, just saying, you know, hey, I heard that there was supervised visitation possibly being set up. What's going on? Have not heard from her. So at this point in time, I don't think that there's been any visits.
All right, let me hear from Mr. Weiss next. Any comment on these visits?
Yes. To update also Beth on this, I received a text message and an email from the owner of that place. And she said she did reach out to mom. Mom responded. And I believe her quote was, "I can't afford that." And that is, I believe, the reason why supervised visits have not happened yet. I have that in email and text, and I will send that to you, Beth.
All right, Ms. Shoemate, any comment?
That is what I said. I can't afford it at the moment.
I would also like to say I did look at in other places, and the that rate seems to be pretty similar for the rest of them. There's not much of a big difference on that rate per hour for the supervised visits.
Right. Ms. Fellows, you're still putting your report together?
Yes, I have been wanting to see if the supervised visits were going to happen. I do have additional information that solidifies that supervised visits are appropriate, that the concerns about Vincent Taylor are still there. And I do have 3 different police reports that actually the father was able to furnish. He did file with the court as well. And they each have mom saying that Vincent is her boyfriend. These were dated 3 different times, 3 different police reports in mid-February. Same time when we had court, and she said that they were moving slowly, that they weren't together, they weren't boyfriend, girlfriend, and same type of thing that she put in her declaration. So there are indeed concerns that Vincent Taylor is a significant part of her life. And there's cause for concern for Taylor being around mom at this point in time, unless it's supervised visits.
Well, there's a concern about him being around the children.
Yes.
All right. As to the supervised visits, I'm not going to make any changes. I hope at some point Ms. Shoemate can afford it. But based on what I've heard today, I'm not going to make any changes, and I'm going to wait for the guardian ad litem report probably before I make any changes again. The next
I do
issue.
have, I do have
go
a
ahead, please.
question. Is it possible to have phone calls if he's in the room?
Say that one more time, please.
Is it possible to have phone calls if he's in the room?
He meaning Mr. Weiss.
Kyle. Yes.
Mr. Weiss, do you have a thought on that?
I would like to check in with Beth on that matter. If she's okay with that, then I would be okay. If there's a reason not to, I would like to speak with her about it first.
At this point in time, I don't think that there is a cause for concern as long as it is just the mother and the father is able to listen in on the phone call.
If that's satisfactory, why don't we start out with one phone call a week between now and May 3rd. And we're going to be back here on May 3rd on a number of issues. And one of them will also be whether the phone calls should be expanded to more than one. And just to put perimeters on that, the call should only deal with a conversation with the child and not discuss any other issues between the parties. Okay.
Okay.
All right, let's go to child support. And so, Mr. Weiss, I want to talk to you a moment. In your worksheets, you list Ms. Shoemate's income as gross income as $3,466 a month, and you're calling that imputed income.
I believe it should be 2,400, not 3,400.
Okay. Okay. It says 3,000 on your worksheet, but I understand if you intended that to be 2, that is more in line with the information I have. And then the amount you're asking for at this point on the child support order is $309.95.
Correct.
Okay. And where did you get that number?
I based that off of full-time minimum wage, 40 hours a week in the state of Washington versus my income.
Okay. All right. Ms. Shoemate, have you looked at the proposed child support orders?
I have, and that's not what I make. I just started this new job, which I only make 16 an hour.
How many hours do you work?
I'm about 28 roughly.
Okay. Just a moment here. So actually looking at a financial statement, Ms. Shoemate, that you provided, I believe you entered your income as 2,432 a month.
I was working a different job. I just started a new one,
Okay.
and I can do those paperwork and send in my pay stubs that I got yesterday.
Am I able to make a statement off that?
Yeah, why don't you go ahead and then I'll see how I want to handle this. Go ahead, Mr. Weiss.
28 hours a week is underemployed. There's no reason why she should not be working 40 hours a week. She doesn't go to school. She doesn't take care of her kids. She doesn't have custody of her kids. So she's not sitting at home taking care of them. She should be working 40 hours a week. Every job she gets is always under 40 hours. It's always part-time. There's no reason why she can't be working 40 hours a week.
Your Honor, I just got done with school and I have to take my state exams before I can get fully paid and get more hours.
All right, I think I want to see Ms. Shoemate's wage statement to see what her hourly rate is. And if I impute it, we typically impute at 32 hours a week. So that potentially could increase the amount that we factor for child support a little bit more than what she's making. But I want to confirm that she's making $16 an hour. So Ms. Shoemate, what I'd like you to do is file your recent wage statement with the court. And we will again take up child support on May 2nd, but I'm probably going to make the payment retroactive to April because we're really here today to decide what child support is, but now it turns out I need additional information. So I just want you to be aware of that. So if we could all be back here on May 3rd, we'll have a number of things to discuss and we'll set temporary child support at that time. Okay. All right. Thank you. Let's go to Kyle Weiss and Carissa Shoemate. I see Ms. Shoemate and Ms. Fellows. Is Mr. Weiss here?
I am.
Okay, up there. All right, let me summarize what we're going to be discussing today. And that is there's 4 contempt motions. 2 of them deal with moving the child without notice. 1 deals with failing to provide a current address. the fourth deals with failing to provide medical, mental health, dental, and school records. And then we're going to revisit the social media account that needed to be taken down. And then finally, we're going to discuss child support. And Mr. Weiss, do you want to go forward?
Sure. Can we get the social media one first?
You're muted right now, Mr. Weiss.
Are we able to start with the social media one?
Yeah, you can start wherever you want. If you want to take up social media, go ahead.
Okay, we're 60 days past the original motion to have that removed. As of this morning, the videos are still currently up. Yeah, those were ordered to be removed back in 2021. She was given 60 days to get them removed, and they are still currently up.
Yeah, remind me again, what platform is that on?
That would be TikTok, Your Honor.
Okay. All right. Let's go ahead and go through all of these, and then I'm going to hear from Ms. Fellows, and then I'll hear from Ms. Shoemate, and then we'll make some decisions. Okay.
Sounds good.
So do you want to take up, there's 4 contempt order to show causes. You want to pick those up?
Yes, that's correct. The first motion was a move from, she had moved from Kath Lamette to Rochester when she had possession of Taylor, and that went against our current court order. That's actually 2 contempts: moving without notifying me, and then removing Taylor out of the school district. She needed permission from the courts to do that. She did not get either one.
When did that occur?
That was, I'm trying to get you the exact date here. That was 2021, just a little under 2 years ago.
And when did you find out about it?
I found out about it the beginning of 2021, several months after it had happened.
Okay. All right, then your second order to show cause, that deals with another move, right?
Correct. Trying to get all my notes together here. Sorry, excuse me 1 second. At some point, she moved again from Rochester to Kath Lamette. That one she never told me about. I found out due to posts on Facebook, and if you can see in my declaration, there are supporting documents, screenshots of her saying she moved to Kath Lamette, and I never received a notice. She eventually moved to Longview after that and informed me of that one, but she never informed me about moving to Kath Lamette at all. And still to this day, she never informed me of it. Once again, I say I found out through Facebook, on her own Facebook.
Okay. All right, then the third one deals with she failed to give you her address. Is that right?
Yes, I'm supposed to get information on her current address. She intentionally left out information so that I would not have her full address, and it made it very difficult to get her served with papers. And the fourth one is I was supposed to have access just to all school and medical records. And when I attempted to receive school records, I was denied. I was not put down as a parent with the school, and I had to jump through loopholes just to get my own personal school records.
for my own child.
Okay. Your child is currently residing with you, is that right?
Currently now, yes.
All right, thank you. All right, I'm going to take up child support after we go through these contempt issues. Anything further you want to say on those issues?
Not at the moment, Your Honor.
All right. Ms. Fellows, anything that you would like to say on any of these issues?
Yes, Your Honor. The mom has made these various moves, as the father has pointed out and has filed the contempt motions. They have indeed happened. Mom has not followed the parenting plan with notifying the father about the moves, going through the appropriate paperwork and documentation to get those moves approved. She has not provided the addresses as she is ordered to do through that parenting plan. So those are indeed extreme concerns that mom has not followed through with. The school records, that has been an ongoing issue, that the father has tried to get the school records and medical records and any other kind of records of Taylor while she was with her mom. These are important records for the father to have once the custody was changed over to him, so then he could get each of those providers. So the school would have updated records, the medical providers and everybody else would have updated records from anything that had happened prior. So it's important that the mother make sure that any ROIs are signed or anything is provided to these said agencies so the father can gather these records.
All right, thank you. Ms. Shoemate, would you like to respond to any of these issues?
Yes, when I moved to Cathlamet, there was a temporary restraining order, so I didn't give Kyle the address at that time because I was told not to, and then it got dropped a little after with no evidence of the case that was going on. And at that time, they did deny him the school records because of the restraining order that was on him. And I did move to Rochester, and I did message him that I did move. I did not know I had to let the courts know. And for the TikTok, it is removed. Her whole account is removed.
Mr. Weiss indicated he was able to access that video this morning. Do you know how that?
I don't, because I had deleted her whole account
When was the account removed?
a few weeks ago.
All right. Mr. Weiss, any response that you'd like to make?
Yes. First point is, yes, she did file for a restraining order. 2, it was never approved at any point. Therefore, she had no reason to move. My second point is she knew 100% she had to get orders from the court. She was served with the same parenting plan I was. She signed it as well as I. She knew better than that. And the fourth one, I can physically show you on my phone that video is still up, and it is under the name Carissa Shoemate.
All right. On these contempt motions, and I'm going to tell you what I'm going to do, and then I'm going to fill out these orders at a later time, just because we have a lot to get to today. So there were contempt motions that have been labeled 1 of 4, 2 of 4. 1 of 4, I'm going to deny because it's remote in time. 2 of 4, I'm going to grant because that is more recent and there is a requirement to contact the parent, even if there was a protection order. I think it's important that the parents be notified of where the children are moving. 3 of 4, I'm going to grant because there was a address, but not the apartment number, and that would have been difficult to determine where Ms. Shoemate was residing. 4 of 4, I'm going to defer for the moment and put this over 2 weeks. And the reason is if Ms. Shoemate provides all of the information that's requested, the physician names, the treatment providers, and also contacts them to release that information. If all that's done in 2 weeks, then I will consider that she's purged whatever contempt there was on number 4, and I will not find contempt on that issue. But I want to give her an opportunity to do that. So we'll put this hearing on that matter over to May 17th and determine what's going on. I'm going to do the same thing on the social media. I'm going to enter an order today that the TikTok account for the daughter be taken down. Ms. Shoemate has indicated that it was taken down. Mr. Weiss, if you've got evidence that you can provide to the court that it has not been taken down in the form of screenshots or something like that, then file that. And if that appears, say, tomorrow or later, then I will find a contempt on the social media issue, and there will be additional sanctions on that. Okay, so I'll do, let me just write a note here. Okay. Now let's take child support. And let me go to your child support order, Mr. Weiss. I just want to get to the number here. Your order says $309.95. Is that what you're asking for today?
Based on current information that I have, yes.
Okay. Ms. Shoemate, any response to the request for child support?
Yeah, you had told me to file my pay stub, which I have. You should have it because I can't afford that with $16 an hour.
Okay, well, what I did, you gave me pay stubs that were $16 an hour and you had worked, I believe, 28 hours. We consider that being underemployed. And so we usually assume somebody can work at least 32 hours. So I factored in $16 an hour at 32 hours. That's $21.50 a month. That's just slightly over what your pay stub showed. And when I ran the calculations, it actually came to more than the $309 that Mr. Shoemate is asking for. So based on that, I am going to enter the child support order that he has presented.
May I add one thing, Your Honor?
Yes, sir.
Are we able to do anything about medical costs, out-of-pocket medical costs for Taylor? I have about $800 worth of out-of-pocket medical costs that I believe she should be helping me with. Can we do anything about that?
Well, those are usually shared on a pro rata basis based on income. So you may need to do the worksheet over again showing her income at 2150 and your income at what you showed to determine that percentage. And then she would owe you the percentage that her income represents. And
Okay.
I would first, I guess, write her and say, and give her the bills and say, you owe me so much. And if that's not paid within a reasonable time, then you can bring that to the court.
Your Honor, she is also on state medical through me.
Your Honor, I understand she's on state medical through her mom. However, once again, I do not have access to that information. And second of all, the only way I am able to use state medical is if I drive my daughter up into Washington for her medical appointments. Her doctor is down here. I'm miles away from the state lines. I'm not going to drive up to Washington every single time. I've got her own medical coverage. Her doctor's down here. Her counselor's down here. I'd like to keep it that way.
All right, well, that, first of all, the state medical information needs to be given.
Your Honor, I've given him a picture of her insurance card.
Okay, good. Then the issue about whether she should be using state medical versus what Mr. Weiss is requesting to do, that's something that would come up at the time of the hearing to pay the uninsured medical expenses.
Sounds good. So I just take our incomes, I figure out her percentage based off the income.
Right.
Instead of doing a split 50-50, it would just be whatever percentage it comes out to be based off the incomes.
Yes.
Understand.
You're I'm signing your child support worksheet, but you're going to need to redo it. The percentages. Oh, I thought I saw it here. Well, you'll need to calculate those percentages based on the income that I gave you. Okay.
Sounds good.
All right. So I've signed the child support worksheet. I've signed the child support order. I'm going to go through and do the contempt orders at the end of the docket. Okay.
Your Honor, I believe that we're also here for kind of a review of the phone calls.
Okay. Have you been aware of how those have been going, Ms. Fellows?
Yes, I believe a couple of them have happened. The first one went pretty good. The second one wasn't so good. My understanding is that mom was only on the phone for maybe a few minutes and then handed it off to her sister and then never came back onto the phone. So that is obviously a concern that she's not, these are supposed to be phone calls between mom and Taylor. There is also a little bit of a concern of, I believe there should be a certain day and time established, which will help out with scheduling issues. So like Tuesday at 7 o'clock or something like that. So that way everybody knows when the phone call should happen. And so lives just aren't holding, waiting for this phone call to happen. And a window of maybe like 10-15 minutes. If mom hasn't initiated the call, then dad can kind of go about his business. There was something about mom wanting to go see Taylor at a gymnastics tournament or gymnastics thing. and really kind of pushed Dad about that. But because her visitation is supposed to be supervised, that didn't happen. So just wanted to let the court know that.
All right. Ms. Shoemate, do you want to address the phone call issue?
Yes, I do actually. When I was talking to my daughter, she had asked her dad to talk to my sister, and he was on speakerphone, and he had said yes. And she was telling me about her gymnastics competition, and she wanted me to go. I said you would have to ask your dad because I don't think I'm allowed to. And he said in the background, I could hear him, that he doesn't know when time he would have to get the time and where.
Do you think we need to establish a set date, day and time for the phone visits?
Your Honor, when we first talked, when I asked the last court date, I asked him during the week, and he ignored me until Saturday, and I got to talk to her like that Saturday morning, and then the next Saturday, I didn't get to talk to her until 9 o'clock at night. And I asked him during the day, texted him, when can I talk to her? And I didn't hear anything until she called me about 9 o'clock.
Okay. Mr. Reese, do you want to address the phone calls?
Yep, the phone calls happened during the times they did because there's been no established time, set time schedule. And number two, I'm in a place on the weekends where I have zero reception until I get home that night. So I didn't get any messages or phone calls till around 9 o'clock that night. And that's when I allowed the phone call to happen. But yes, I do agree there needs to be a set time scheduled.
What's convenient for you, sir?
Saturday mornings, 9 a.m., 10 a.m.
All right, you just said that you're out of range of the cell phone on Saturday. Is that later in the day?
Yes, that would be later in the day, and I can hold off on that until the phone call happens.
Okay. Ms. Shoemate, and I'm open to hearing what's convenient for you, but let's start with, would Saturday at 10 work for you?
Yes.
Okay. All right, let's make the phone call Saturday at 10. And Ms. Shoemate will initiate those calls.
Thank you, Your Honor.
Okay, all right. Let's take up the other issues on the 17th when we come back then. Okay.
Thank you.
All right. Thank you.
Your Honor, this is Beth Fellows, guardian ad litem again.
Yes.
I ask that the Kyle Weiss and Carissa Shoemate case be called, please.
All right, we can do that. Kyle Weiss and Carissa Shoemate, are you with us?
Yes.
Ms. Shoemate's here.
I'm here, Your Honor.
All right, Kyle Weiss is up there. The two issues that I think are on for today, and everybody can correct me if I'm wrong, was Ms. Shoemate was to provide medical information to Mr. Weiss, and then we were going to once again review the social media account. I did see a subsequent declaration, and I have some questions about. I did see there were motions for reconsideration filed. We are required to hold those for 10 days, or at least my staff does. And so those don't formally get to me until May 20th, which is 10 days after they were filed. So I did see them in the court file, but I haven't been given those. They haven't been given to me formally at this point. Mr. Weiss, let's start with the medical information. Did you receive that?
I haven't received anything as of today, Your Honor.
All right.
Disregard, I did ask for Taylor's medical card. She did provide me with that. However, any other documents I have not been provided with.
So you don't have a list of where Taylor has been treating over the last, say, year, 2 years?
I do not. And I want to speak for the record. The medical card that I was provided for Taylor is a invalid insurance plan. It is through state healthcare. Taylor is not a resident in the state of Washington, therefore she does not qualify for state healthcare. I wanted to just state that for the record, and everything else, no, I've not been provided.
Okay, and while I'm talking to you, you provided a page of screenshots from, I assume it was TikTok. And when were those screenshots taken?
Just a couple days ago.
Okay. All right. Ms. Fellows, anything you want to add at this point?
No, Your Honor, I don't have anything, any additional information.
All right. Ms. Shoemate, 2 weeks ago, I believe I asked that you provide the medical treatment information to Mr. Weiss, and it sounds like that has not occurred. Can you address that?
I'm still working on that. I just trying to remember. I know one of her doctor's offices I'm here that she's been to for a while, but the one in Rochester, I can't remember the name of the clinic. I'm trying to look through my paperwork that I had for her because I keep all documents from doctors, but I have that in storage, so I'm trying to find them.
Did you understand that if that was not provided by today, I was likely to find you in contempt?
I do understand that.
Okay.
And to the TikTok, I just found the that TikTok account that he's talking to. I am in the process of trying to delete that one. I'm trying to remember how I did her other one because it's been since 2020 since she's had that one. So I'm trying to figure out how to get into it.
Your Honor, my response to that is that was the same response when we first brought this to court, is she was trying to figure out how to delete it. We've held this one over 3 to 4 times, a couple months now. I think that's been plenty of time.
Your Honor, well, I didn't see this one until I got his declaration on which one, and I just found it, and I am trying to get into it.
Okay.
Because to be honest, I did forget about this one. She did have a different TikTok, which I trying to figure out how I deleted that one. But I did get a hold of, I sent a message to TikTok saying it's court ordered to be taken down, but I'm hoping it will be taken down.
All right. As to the contempt that was brought on the medical information, I'm going to find that there is contempt. I think I still have the order that was provided, and I'll sign that. I'm going to put this over 2 weeks to the 31st. At that time, the medical information will need to be provided or the sanction will increase. I'll find another contempt at that time. So I'm finding one today, and I may find one 2 weeks from now if the medical information has not been delivered. As to the TikTok account, I'm going to enter a separate court order indicating that that account needs to be taken down. And the purpose of that is if Mr. Weiss wants to take that order and take steps himself to get that account taken down, he can do that. Additionally, the order will say that the daughter cannot maintain any TikTok accounts until she's 18. I think I made it clear that if the concerning material on TikTok was not taken down, that I would prohibit the daughter from having a TikTok account going forward. So that's what I'm doing today. All right. We'll see everybody back here then on May 31.
I have
One,
a question.
me too. She can go first though.
All right, go ahead, Ms. Shumate.
For the medical, am I just sending him the name of the clinic, or what exactly am I sending him?
I think, yeah, I think what we're asking is the name of the clinic where she's treated and what her current insurance status is.
Okay.
Your Honor, I think that there needs to be like potentially releases of information signed by the mother, because I think the father has in some instances been restricted from accessing any information. So in order to make this a smoother process, it makes more sense that not only, you know, name, address, phone number, contact information, but also an ROI must be signed by mom to allow dad to talk to the provider and gain those records.
Okay. I will agree to that. So on each of the medical providers where your daughter is treated, then Ms. Shumate, you'll need to get a hold of them and sign whatever documents they have to allow Mr. Weiss to discuss your daughter's treatment or care with them. And that's typically called a release of information or an ROI, as Ms. Fellows has indicated.
Okay.
All right. That needs to be done in the next 2 weeks also. Okay.
Okay.
And then I'll
Mr.
finish.
Weiss, question?
Yeah, I know you said you can't do the motion of considerations right now. Will those also be on the 31st?
No, those are usually handled without oral argument. I'll just base it on the pleadings that you submitted.
Copy. How will I find out the results of those?
I will write a decision and that will be sent to everybody.
Sounds good. Thank you.
Okay.
Thank you, Your Honor. So we'll see you on the 31st.
On the 31st. All right. Thank you. The next case we're going to take is Kyle Weiss and Carissa Shumate. I know Ms. Shumate is here. Mr. Weiss here.
I am.
All right. Did you receive the medical information that I required last time we were here?
I received notification from Miss Shumate through text message that she had added me so I could receive medical records at 2 locations. One was Centralia, one was in Longview. However, I believe there's more facilities she's not telling me about due to previous medical records. I don't know why that wasn't disclosed to me in the initial conversation. So yeah, that's where we're standing on that right now.
Do you know, do you have any information about the previous facilities?
Yeah, Miss Shumate lived in Vancouver for almost 3 to 4 years, and my daughter was seen in facilities around Vancouver several times, and she did not disclose that information to me. She only told me about Longview and Centralia.
Okay.
Your Honor.
Any response? Go ahead.
The one in Longview is the main branch. The one in Vancouver is the same number. So when you call, it's the same number to get to any clinic.
What's the Longview?
Child adolescent clinic.
What is the facility?
The child
Adolescent.
Yeah.
And did she attend that, a branch of that in Vancouver?
Yes.
Okay. Were there any other medical providers in Vancouver?
No, it was just a child adolescent clinic unless she had to go to the ER.
Did she go to the ER?
She had twice
Okay, where did she go to the ER?
in Salmon Creek.
What is that,
I
Legacy Manual there, or what is the hospital there?
I believe it's Legacy.
Okay. All right, Mr. Weiss, any response to that?
That would be the one that's in question, is the hospital there in Vancouver that was not disclosed initially. And she told me she added me so I could get a hold of records, but I'm not 100% sure if she signed any ROIs to allow that. I don't know if that's been done or not.
You're talking about the child and adolescent clinic at this point?
For every single facility she's had Taylor in, every single one of them.
What have you done to give Mr. Weiss access to these facilities?
I have called them and asked them what I needed to do, and all they said was to add him as the father because he is the father that once he's on there that he can just call.
All right. Have you attempted to call any of these facilities to learn about the information, Mr. Weiss?
Not yet, Your Honor.
All right. All right, Ms. Shoemate, I want you to do the same thing with the hospital at Salmon Creek. I'm going from memory to say that's Legacy Manual, but it may be in another hospital. Mr. Weiss, I want you to check with the facilities to make sure you have access. And I'm going to put this over for a month. And essentially what I'm putting over is the contempt hearing to make sure that all of these accesses are working. So I'm going to put this over to June 28th. And that'll be at 9 o'clock.
Sounds good. Are we also discussing the social media today?
Well, I entered in orders that you can access with the clerk's office that gives you authority to take it down.
It's been taken down, Your Honor.
Okay. And Mr. Weiss, if you're not convinced of that, you can come get the order. It gives you the authority to deal with TikTok.
Sounds good.
Okay.
Excuse me. Yeah, number 2 and 3 on our docket, which is 173000404. This is Kyle Weiss and Carissa Shoemate. Do I have you folks present?
Yes.
Yep.
Okay. Great. So I'm going to start first. Well, let me get into the digital file first, I should say. And then is the state of Washington present on this for temporary orders?
I am present, Your Honor, today, but we're not addressing child support.
Okay. Okay. So what I see as the first issue, and I'm going to fully acknowledge that this case has been, as the parties know, going on for a lengthy amount of time. I am sure there is history to this case that even if I read every single document back to 2017, I still would not fully be up to speed on. So just know that correcting me about facts of the case or what the parties are wanting to do today is perfectly acceptable. Jump in if I'm getting something wrong. But the first thing I see, and we'll try and take it step by step, is that they're originally back on May 31st, which was the most recent hearing with Commissioner Nelson, that the Ms. Shoemate was ordered to include Salmon Creek Legacy in an ROI. And the father was going to check that he had access to the child's medical information and that would be reviewed today. It looked like there was a contempt finding on that issue on that date. So let's just start with that specific issue. Ms. Shoemate, have you been able to make progress on that?
Yes, and I have sent it to Kyle.
Okay. And sir, have you received access to the medical records?
Your Honor, the only thing I've ever received from Carissa is a text message with a phone number and an address. That is it. That's the only thing I've received from her.
And what is the phone number and address? Was that to Legacy, or what was that a phone number and address for?
It was to Legacy, but there's been no information about an ROI signed or anything.
Okay, so you don't have you been able to log on and see whether you have access to the child's records?
I do not have access to the child's records because no ROI has been signed.
Okay, so Ms. Shoemate, tell me what's going on with that.
I was told because he is the father, I didn't need to do that, but he should be able to just call and they should be able to talk to him.
Who told you that?
Somebody in the medical records.
Okay, so you are aware, I understand you might have taken that directive from someone in medical records. But on May 31st, a judicial officer in this superior court issued a contempt order, finding you in contempt and stating that the contempt could be purged or corrected if you provided names of medical providers and signed a release of information for each. And it sounds like you have not done either of those things, but instead chose to ask medical records if you should do it. Am I wrong in my understanding of what's happening here?
No, I talked to somebody in medical records, told him it was court ordered that I signed something for him to have medical records, and they said I didn't have to, that he needs, because he's the father, he can call.
So I'm just going to ask you a question, do you understand the order that was signed by the judicial officer mandating that you do that? Have you seen that? Do you have it in your possession?
I do not.
Okay. Were you present on May 31st when Commissioner Nelson ordered you to do those things?
Yes.
Okay. So help me understand why your decision was to ask someone in medical records if you needed to do it versus simply doing it and complying with the judicial officer's order.
I was asking how to do the ROI, and I was told not to. I didn't have to because he's the father.
And Your Honor, the issue I run into is every time I call stating I'm the father, I have to prove it. I have to jump through loopholes. I have to get birth certificate. I have to prove who I am. I have to physically drive in to give my ID. I shouldn't have to do that. I should already be on there to have information. That's why the release of information is necessary.
Yeah. I mean, frankly, sir, I have to show my ID when I take my kids to the doctor's office too. I mean, that's not a huge hoop, but here's what I'm going to do on this issue. Ms. Shoemate, regardless of whether medical records tells you you do or do not have to do this, the fact is there is a Superior Court judicial officer who has signed an order that has a binding and legal effect on you that states you do have to do this. So I'm not asking you to call medical records and ask them whether you need to do this. I'm telling you that you need to sign ROIs listing Kyle's name as someone who can get any and all access to the child's medical information. So I'm not going to find contempt again today because I think that would be your third contempt finding. I'm going to give you a little leeway, but not much. So I'm just wanting to be very clear today that before I let you parties go, we will set a review date just a couple weeks out. If it is not done by then, if you haven't filled out the releases of information, then I will entertain another argument on contempt, which would be your third contempt finding. So I just want to be very clear. Go to the facility, fill out the ROIs with all of the medical providers' names, listing Kyle as the person who can receive and access information. That's all you need to do. You don't need to ask someone if you need to do it. You just need to do it. Okay?
Okay.
Your Honor, I believe we do, in previous hearings, we did ask for also every school record as well. Do you have that document?
I don't. I just have, the only thing I show in the last hearing minutes was that you all discussed obtaining medical ROIs to include Salmon Creek Legacy and any medical providers.
Okay, may I put in a request to do schooling as well, every school she's been to?
Ms. Fellows, what's your understanding of that request? I don't see it in front of me, so I don't necessarily want to pile on, but.
What I can say is that there have been a number of schools that Taylor has gone to, and to be able to track down those records has been very cumbersome. Mom has not exactly been forthcoming about all the schools, and the father's just trying to get all of the records together for her to have. So I would actually add that as well. Yes.
Okay. So what I'm going to do today then is an actual, just a bench order. I'm going to reiterate the ruling of Commissioner Nelson regarding the ROIs for medical. And then it sounds like, and sir, you can correct me if I'm wrong, you're just wanting her to provide a list of all the schools and then ROIs for those schools?
Yes, so that I myself can obtain all records that I am seeking myself.
Okay. Okay. I will add that to the bench order, ma'am. Do you understand that you'll need to provide a list of schools attended and ROIs for those schools as well?
Okay.
So because of, we are adding a little bit of homework to you, let's go 3 weeks out. I'm thinking, I was originally going to do 2, but let's do 3. I think that'll put us July 19, if I'm not mistaken, at 9 a.m. Will that work for the parties? That'll be, to be very clear, that'll be a review date to make sure that the ROIs for medical, the list of schools, and ROIs for schools have been completed.
Okay.
Your Honor, I would ask maybe to make it easy.
Yes.
Is mothers should have a list to be able to list off all of the schools and the dates that she signed the ROIs, and a list of the medical providers and the dates that she signed the ROI, and be able to provide that to court on July 19th. That way, in my mind, it would be very clear to all parties on where those ROIs, or what agencies and schools, and what date those ROIs were signed.
Okay. I can absolutely add that to the order. Thank you for the input. I appreciate it. So what I'll do is make a note. Sorry, do you? I could take a break. Sure. Now I feel bad. Okay, I think, all right, so I'll put that in the bench order. The parties will receive a copy of that bench order from my judicial assistant. And it's going to be very clear, ma'am, what we're wanting. And that on July 19th, I want two things to have happened. One is for you to have completed the tasks. And then number two, try to, with a few days before that hearing at least, so I can actually have it in our court system, please file with the court clerk the proof of the listing of the names of medical providers and schools, and then the dates that you did sign ROIs with each of those agencies, okay, or facilities.
Okay.
Do you anticipate any difficulty in getting that done before July 19th?
I know a couple of them are out of town, so it's getting there is the problem.
So we are in summer months. So first I would probably call district offices wherever those schools are located. I know the schools themselves probably won't be open, but the district offices will operate all summer. I'm sure it's something that they're very used to doing via email. So I would just recommend you do some legwork actually calling the districts for those schools. Okay.
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 And anything that she files, that she needs to provide copies to both myself and the father.
And ma'am, do you know how to send copies to Ms. Fellows and Mr. Weiss?
Yes.
Okay. Okay. So that'll take care of the contempt and review issue. I am also showing on this matter that we're here to discuss temporary orders. Is that the party's understanding?
Not quite sure. I
Okay.
know today was about the medical IROIs.
Okay, so I'll tell you, ma'am, have you received, I'm looking to find a date here. Mr. Weiss did submit a temporary family law order and a temporary parenting plan. Oh, these are old ones as well. These were back from January. So are the parties wanting to hold off on temporary orders until our next review date?
Yes.
Yeah, yes, Your Honor.
Yes, Your Honor.
Okay, and so Mr. Weiss, what I would say is because the last orders I have are January, if there's something that you want the court to review more recent, I would submit new orders. And if nothing has changed in your request since January, certainly no need to submit anything new, and you can just let me know that. But you know, again, I know this case has been going on some time. I don't know if the situation has changed since January, so just a heads up for you.
Sounds good.
Okay. And then I know since the state is here, since we're not taking any action on temporary orders, is there anything, any state input at this time? Okay. Oh, sorry. I probably caught you a little off guard.
No, I was having a hard time getting unmuted, but no, we're only here as to child support, Your Honor, so we have no input today.
Okay, thank you. All right, anything else, Ms. Fellows, Ms. Shoemate, Mr. Weiss, that you need on this matter? I show that kind of takes care of what was on my list to do. Please tell me if I've missed something.
No, I think that's about it for today.
Okay. And then we'll see the parties back on July 19th at 9 a.m.
All right. Thank you, Your Honor.
All right. Thank you all. Let's go to number 3 on our docket. This is Kyle Weiss and Carissa Shoemate. And I believe we have Ms. Fellows on that case as well.
Yes, Your Honor.
Okay. Good morning. This is 17-3000404. Do I have Mr. Weiss with us?
I'm here.
There you are. And do I have Ms. Shoemate?
Yes.
Okay. Let me pull up your digital file. Give me just a minute. Okay. Okay, so by my notes, we are looking at an update on the ROIs for medical and school records, and we specifically set the review today for that. What, Ms. Fellows, maybe first I'll turn to you. What can you tell me about any knowledge you have on that issue?
Yes, Your Honor. The mother has provided ROIs for 3 medical facilities, Child and Adolescent, Legacy Health, Northwest Pediatric Center. And there's only one for school district, but I'm not sure this actually requests for student records is like Wahkiakum School asking for school records from other places. So I don't think that this is a correct one. But there are 2 other school districts which there are no ROIs from, which is Vancouver and Rochester.
Okay. So it sounds to me, Ms. Shoemate, that Ms. Fellows, let me ask you, the 3 medical facilities, does that seem to be a complete list of the medical facilities?
I think so. I believe so.
At least based on what information we have right now.
Yes.
Okay. Okay. So Ms. Shoemate, it sounds like we've addressed part of the issue here, which is the medical facility ROIs. What can you tell me about, let's start with the 2 school districts, Vancouver and Rochester, that you haven't been able to get done?
I just got emailed yesterday. It's been a hassle between Vancouver and Rochester, but I just got emailed the ROI for Rochester yesterday. I called yesterday again for Vancouver, and she transferred me to the girl I was supposed to talk to and left a message. So I'm trying to get Vancouver's to answer me so I can get the ROI for Vancouver.
Okay.
Because I did talk to one of the ladies there at York Elementary where she was going, and she said because they're shut down right now because they're putting new carpeting into Call District. And so I tried calling and left a message. I still haven't heard anything.
Okay. And it sounds like we need, so my thought is let's do a short 1-week review date for the school ROI. So if you can keep working on that, Ms. Shoemate, thank you for getting the medical information. My thought is just setting this over 1 week to 7/26 at 9 a.m. to make sure we get those school ones completed.
Okay.
Does that work for you, Mr. Weiss, and you, Ms. Fellows?
Yes, it does. And again, excuse me, I'm sorry. The Wahkiakum School District request for student records. Again, I don't believe that this is the correct form.
Okay.
But she was kind of confused on why I had to. She said that she didn't quite know what to send me, so that's what she sent me, and I signed it. She said she's just gonna put it in the file so Dad can call and get them. She says she knows it's for like another district, but she couldn't find the right form for me for personal the ROIs, so that's what she sent me.
So it does sound like it's not the right form. So
Right.
to reach back out to them and try and get that addressed before next week.
Okay.
Okay. So I'll just continue reviewing this in 1 week. Is there anything else we need to address? And again, kind of with an older case with a long history, I'm just going back to see if there's any loose ends that we need to set dates for to address. And I think Ms. Looney, you're on this case for child support.
That's correct, Your Honor.
Are there any, I did see a proposed worksheet back from May that doesn't appear to have a judicial officer's signature, but then I think there was a child support order. Are there any loose ends from the state's perspective on child support we need to address?
We have not entered a new proposed order yet, Your Honor. We were waiting for there to be a new parenting plan in place because custody was at issue. So we were waiting.
Okay, so it sounds like we should set a date for a discussion of these orders. Ms. Fellows, how close do you think we are to discussing parenting plans and child support worksheets and orders?
We're there now, realistically. Taylor has been with her father for a couple of years now. And I think visitation, things like that need to be discussed and tried to figure out. Right now, the mother is allowed to have professionally supervised visits as long as it is in the area of where the child lives, which is in Oregon. The mom had said that she cannot afford it. So that's where we're at with that.
Okay. Is this in a posture, and again, apologies, this case has a lengthy history and I'm doing my best to get caught up here. Is this in a posture? It does look like we would be entering final orders on visitation. Is this one that you think would be ready for me to issue an order transferring to mediation and then coming back, or what's your thought?
I don't know if mediation is a viable option given the parties and their history. As you have stated, there is a lengthy history. But yeah, it does need to move forward towards final orders in one way or to other.
Okay. Let me ask Ms. Shoemate and Mr. Weiss, are you folks wanting some time to try to work together on agreements on those issues? Or do you believe that especially parenting time is something that you both are going to be requesting a trial on?
I would like to have my weekends back. I'm no longer with Vince, who is the reason why I got my daughter taken away.
Mr. Weiss, what's your thought on the potential for agreement on parenting plans versus something that we should start moving you all towards trial?
I mean, we can start with mediation. It's worth a chance, but if not, yeah, let's go for finals.
Okay. Ms. Shoemate, would you be open to working with Mr. Weiss in a mediation format to see if you could come to agreements together without taking the case to trial?
Yes.
Okay. Why don't I do this? Well, we have our review date for next week on the ROIs. Let me, because we are working towards final plans, I will transfer this case to mandatory mediation to address visitation and parenting plan. And I'm looking, let me go back and look at the proposed child support worksheet as far as cost for this.
Your Honor, can I rephrase one of my statements? Can we just try for finals?
Can we do what?
Just move for finals instead?
Meaning bypassing mediation?
Correct. I would like to rephrase my statement if I can.
So you don't believe mediation would be fruitful in this case?
Correct. After some careful consideration, correct.
Okay, and what would be the basis for that statement? Because my original ruling to transfer you all to mediation was based primarily on both of you stating, hey, let's give this a try, this could work. Tell me what has changed your mind.
I just don't think we're just going to come to an agreement in mediation. I think it's going to go straight to the what you guys call finals. So I just don't think it's going to be worth the effort, in my opinion.
So what I think I'll have you do then, for our hearing next week, present me with a motion for waiver of mediation, and I'll rule on whether there's good cause for that. You'll find that in our the discussion of that in our local court rules in Cowlitz County. And I believe it's Cowlitz County Local Rule 93. Okay. But I would encourage you to think about, in the meantime, before we reappear next week, whether there's any room for agreement. And then if not, next week, we'll get you guys probably set on a trial assignment docket to schedule you for trials on your proposed final orders. Okay. 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 Well, we'll see you all back next week on the ROI issue. Ms. Fellows, anything else from you?
No, Your Honor, thank you.
Okay, thank you. And do you have, Ms. Fellows, number 2, I believe I see Kyle Weiss and Carissa Shoemate both online.
Yes.
Yes, I'm here.
Perfect. Okay, so let's take that. That's number 2 on our docket. This is 173-000-404.
And Beth Fellows, GAL, is present as well.
Good morning, Ms. Fellows. Thank you for being here. When I reviewed the last hearing when we were all together, my understanding, we're doing a couple things today. One is we're going to get an update on the ROIs from Ms. Shoemate. Number 2, we're going to discuss Mr. Weiss's motion to waive mediation. And then depending on the outcome of that, we're going to talk about where this case goes in the future. Does that sound right to everyone?
Yes.
Yes, Your Honor.
Okay. So I guess I'll start. I don't know, Ms. Fellows, if you have an update for the court on the ROIs and where we're at with that.
I do not, Your Honor. I have been out of town, out of my office, so I don't have any information on whether or not she's provided more ROIs or not.
Okay, totally understandable. Mr. Weiss, have you received any additional ROIs or corrected? I know one of the issues was we were waiting on corrected ROIs. Have you received any of that?
I haven't received anything since last court hearing.
Okay. So Ms. Shoemate, I'll turn to you now. I think, as you know, we originally were here on a motion for contempt over some of these issues. I didn't find contempt, but I did set deadlines for you to get those things done. We came back July 19th, and we were still waiting on the corrected form for one of the school districts and then any forms for other school districts. Where are you at with that?
I just received Vancouver's yesterday. So by the time I got off work, I wasn't able to file it. And then for the one for Wakaikam, the one that is not correct,
the ROI. I did get a hold of the school and talk to the superintendent. That's the only ROI they have. And he said that they know that if Kyle calls it's for him. So I don't know exactly what to do for that one.
Okay. And then what about Rochester?
I filed that one, I believe.
We didn't have it on July 19th. Have you received it since then?
I know I have one from Rochester. I thought I filed it on the last hearing, last Tuesday, I believe.
We did not have it last time. So
Oh,
so let's do this. I guess I'm not sure. So Mr. Weiss, what we'll do with the Wakayakum form, we will set a review date. And if you have difficulties using the form that they've presented, certainly bring that back before the court and we'll address it. I feel like my hands are a little bit tied if the school district is saying that's all they have. But Ms. Shoemate, I'll have you get the ROIs for Vancouver over to Mr. Weiss. If you haven't given him Rochester, you need to do that.
okay.
And then I think we had taken care of the medical facilities.
Yes.
So let's just do, and it should be a pretty quick appearance next Wednesday at 9 a.m. just to make sure that he has received all 3 of the ROIs for the school district. Mr. Weiss, if you have by next Wednesday, you could strike that review.
Sounds good.
Okay. But for now, we'll put you on for next Wednesday, which is that August 2nd?
Yes.
Okay. August 2nd at 9, just to review that. Let's talk about the waiver filed for mediation. Ms. Shoemate, have you received a copy of that?
I just got the email from Kyle.
Yeah, so we had originally discussed this at the last hearing, excuse me. So although it technically, I think, Ms. Shoemate, if you wanted to object and have us hear this next week because of timing, that's fine. But my thought is if Ms. Shoemate, you feel ready to proceed on that today, the court would just be hearing from the both of you as to whether or not to waive mandatory mediation.
We can do it today.
Okay, I think that makes sense for you all in getting some resolution to this. So what I have done is I have reviewed the declaration in support of waiving mandatory mediation for Mr. Weiss. I have received it. And reviewed it. I did also go back and just review notes from our last hearing where this was discussed briefly. And essentially, Mr. Weiss is asking this court to find that given how far apart the parties are on issues related to kiddo and how contentious a lot of this has been, including motions for contempt and that sort of thing, that mediation would be highly unlikely to be successful. Mr. Weiss, I know your position. Ms. Shoemate, what is your position on that?
I would like to do mediation and be adults and co-parent. Last time, I believe it was like back in 2018 or 19 when we first did it, we didn't really have problems doing it the first time.
Mr. Weiss, any response?
Yes. The first time we did it, there were several, and I mean several incidences and circumstances that were different. Everything is completely different compared to the first time we've done it. I mean, I could go on and on the reasons why mediation is probably not going to work. But yeah,
don't think we're going to be able to agree.
And Ms. Fellows, any input on this specific issue?
Yes, Your Honor. I did read over the father's declaration, and that's one of the reasons why I said what I said last week about mediation, that I did not think it would work. This case is not suitable for it, for that platform. They are too far apart. There's been a lot of things that have happened. These are not two parents, unfortunately, that are going to be able to move forward co-parenting. And they're nowhere near the same ideas on the custody matter. And there's just so many issues, and there's no common ground. So I really do feel like mediation is not the platform for these parents.
Okay, I appreciate that. So here's the court's ruling. I am going to sign the order waiving mandatory mediation. I do find there's good cause to waive mediation in this case. I would say, Ms. Shoemate, I just in my brief time being involved in this case have had to hold your hand through a lot of things that I feel like could have been done without court involvement. So I just don't see how this case concludes quickly without court involvement. So I have signed the order waiving mandatory mediation. I have filed that with the clerk. What I think we need to do now then is get a date for the two of you to get on our trial setting docket, so you can start thinking about how far out you want to get a trial to finalize orders in your case. So our trial setting dockets are Wednesdays at 1 o'clock. What date would you all like to be set on?
I'm good for next Wednesday if it's open.
What about you, Ms. Shoemate?
I have to give a 2 weeks notice to get that day off.
Okay. What about, would Wednesday, August 9th work for you?
Yes.
You may want to clarify that this is just a short little hearing just to set the trial date. It's not for the trial itself.
Yes. Thank you, Ms. Fellows. I sometimes forget when folks don't go through this process every day. So for both of the parties, it's called trial assignment. It probably will take less than 20 minutes all said and done, meaning 20 minutes for everyone on the docket to get trials set. So your particular case, probably a minute or two. And they'll be asking, how many days do you anticipate needing for trial? And what month are you thinking you want the trial to take place? And then they'll give you a week where they'll set your trial date. Does that make sense?
Yeah.
Okay.
I'm a caregiver, so they just need to find somebody to be there until I'm done.
Yeah. So let's go ahead. I can put this on the August 9th trial assignment docket at 1 o'clock.
Okay.
Okay. And then just like when you log into the Cowlitz County Superior Court and you click this Zoom link, there will be a Zoom link that day for trial assignment.
Okay.
Okay. Any questions for me about what we've done today? You have next week a review on the ROIs on this docket at 9 a.m. And then you have the trial assignment the following week, Wednesday, August 9th at 1 o'clock.
Your
Okay.
Honor, I did have a question, and I'm not sure that you can answer it. My last report was filed, I believe, in December of 2021.
Okay.
There have been a number of things that have happened between then and now. And if we're going to trial, would the court like an updated GAL report or not?
That is an excellent question. And I think with these two proceeding pro se. I do think an updated report, albeit it doesn't need to be as lengthy as the initial, obviously, but I do think an updated report would be beneficial for the parties' preparation for trial, as well as the court understanding how long that trial might need to take place. So I do think that's a great idea. Do you need approval of additional hours or fees for that?
Yes, please. That would be much appreciated.
Okay. If you want to submit a proposed order for me to sign based on today's essentially ruling that we will need an addendum report and the parties are moving forward to trial. If you send that to my attention, I'll make sure to get that signed.
Okay. Okay. Thank you, Your Honor.
Yes, thank you. And then maybe what we'll do, since we are going to keep an eye out for that, maybe we set a review about 30 days out, or do you want a little more time?
I would say a little more time. Let's see, 30 days out would put it at the end of August. Maybe mid-September.
Okay, let's do like September 13th.
Okay.
At 9 a.m. for review of GAL addendum report.
Okay.
And then Mr. Weiss and Ms. Shoemate, what I'll just tell you is you can still go ahead and set trial. I would just set it beyond September 13th. So you both have the benefit of that information. And frankly, you're probably not going to be offered trial dates before September anyway.
Okay.
Yeah. Any questions?
None. No.
Okay.
Thank you, Your Honor.
Yes, thank you all. You are free to log out.
Thank you. Have a great
Thank
day.
you. You too.
Your Honor.
Yes.
This is Beth Fellows, and I see Kyle Weiss has joined us. So if we could go back to number 1.
All right, let's do that. Thank you. Let's go back to number 1, 1730000404, Kyle Weiss and Carissa Shoemate. Mr. Weiss, I see you there. You'll probably need to unmute and turn your camera on.
I'm present.
There you go. I hear you. And Ms. Shoemate, can you hear the court?
Yes.
Okay. So I had this on essentially for a quick matter to follow up on the ROI issue and where we are at.
I have gotten all 3 of them, and I emailed and mailed them to Kyle, and I emailed them to Beth.
Okay. Have you received those, Mr. Weiss or Ms. Fellows?
Yes, I did. I received them about 6:30 via email on Monday.
Okay. Does it look like we have what we need now? Are there any of those that we have to go back to the drawing board on?
It looks like they are appropriate, but I don't know. Excuse me, we won't know for sure until Mr. Weiss actually utilizes them and to try to get the information.
Okay. Mr. Weiss, is that accurate to you?
I have not received anything yet in my email or the mail at all.
Sounds like it's on its way. And based on what Ms. Fellows is telling me, my plan, especially since we've got you guys on, moving towards trial setting now, and we actually are moving forward. I'm going to, excuse me. I am going to not move forward with any sort of contempt on the ROIs, but I believe, correct me if I'm wrong, that we have a review date already set for September 13.
Yes, that was to review the updated GAL report.
So what I'll just add to that list, or well, let the parties know, if certainly you could re-note sooner if there's an issue with the ROIs that you need court involvement on. Otherwise, I'll make a note to check in with the parties at that review hearing to see if there's any tweaks we need to make to the ROIs, okay?
Okay.
Okay, that's all I had on my list. You guys are on universal trial assignment today, or excuse me, next week, August 9th at 1 o'clock. And that's the date where you all will log in and let them know how many days of trial you're anticipating needing.
Okay.
Yes.
So just to be clear, August 9th is not your trial date. It's just to set your trial date.
Okay.
Okay. Any questions for me or anything else the parties need from the court today?
No.
Okay.
Thank you, Your Honor.
Okay. All right. I'm going to go through my docket as I have it, and we'll just be starting with the oldest cases first. Number one on my docket is Weiss and Shoemate. This is 17-3-000-404. And I believe we have Beth Fellows on this case.
Yes, Your Honor.
And Ms. Looney, are you on this case as well?
I am, Your Honor.
Okay, great. And then do I have Mr. Weiss?
Yes.
There you are. Okay. And Ms. Shoemate?
I emailed actually both parties, both parents, because they didn't realize that they had court. I just got an email from mom saying that she's at some appointment.
Okay. And I was a little myself confused what we were doing for today's review hearing, other than it might have been set before this case went to trial assignment. So I do see now that the case is on for trial readiness, and pre-trial. Yeah, go ahead and let me know if there's something you think we need to do today. Otherwise, I'm kind of inclined simply to strike it.
Well, it was basically to review the GAL report. I have not filed it yet. I plan on filing it by next week. But I do have some questions. Number one is we have a pretrial readiness. Pretrial management hearing on the 20th, but it's judicial conference week. So I'm not sure if that's an accurate date.
Yeah, that is going to get moved, I would assume. Is that right? Okay. So the court is asking for us to go ahead and move that now. And I know we don't have Ms. Shoemate here, but we'll go ahead and renote it for the 27th at 9 a.m.
And I do have another question.
Hold on one second. We're just let's get this done for the court. Wednesday, September 27th at 9 a.m. on this docket for pretrial.
Okay.
And then I'll make sure we have someone reach out to Ms. Shoemate to inform her of that change.
Okay.
Okay, go ahead, Ms. Fellows.
Yes, I do. There is another issue that actually the dad had brought to my attention. We are set for a parenting plan modification. However, there's never been a final parenting plan filed and signed. So I think that there was some confusion because this has been such a long-standing case. Mm-hmm. There was a CR2A agreement way back, I believe in 2018, I think. But there was no final parenting plan filed. And then we were back in on September of 2021 is when I was reappointed. Judge Hahn was hearing the case and did order grant the GAL recommendations, and a temporary parenting plan was put into place in December of 2021. So there's never been a final parenting plan. It's only been that temporary parenting plan. And so I'm not sure if what we need to do to make sure that this upcoming trial is named correctly, if that makes sense.
Yeah. Hold on, I'm just going back to 2021 here quickly. Lots of orders on contempt in between, lots of motions, adjusting visitation, just as bench orders.
I believe it was December 6th, I think, of 2021, where we had court. Judge Hahn made the orders. And I believe it was December 21st, where Judge Basher signed the presented orders for the temporary parenting plan.
Yeah, I see the temporary parenting plan. So I think what I want to do, because Ms. Shoemate isn't here, I don't want to get too far down the road of making decisions on this, but I think that we should list that clarification of the trial issue when we are together on September 27th. My gut is that this would then be, rather than any sort of modification, what we're looking at is permanent orders, is what the parties would be presenting. And I think we previously discussed how we did not believe, we did sign the order waiving mandatory mediation. But yeah, I think you're absolutely right on that, Ms. Fellows, is that we wouldn't be calling this a modification trial. This really would be a final orders trial.
Correct. And so I'm not sure if we have to go through the whole trial assignment process again, or if the court can, when we come back on the 27th, talk to the party and then basically just rename it.
Yeah, I think that makes a lot. Yeah, I think that makes a lot of sense to me. I'll put a note for myself on the 27th, assuming the parties are in agreement with that. And the parties go into trial, it's set for one day, so still plenty of time to address that issue. So let's confirm that on the 27th. If for some reason there's disagreement once Ms. Shoemate is online, we certainly can put it back on trial assignment and get a different date. But for purposes of your report, Ms. Fellows, I think it makes a lot of sense to focus on the final parenting plan versus any sort of modification.
Yes.
So I appreciate you bringing that up. Ms. Looney, any input from the state at this point?
No, Your Honor, my only question was regarding that pretrial hearing, so we're good.
Okay, all right, Mr. Weiss, we'll see you back on September 27th. We'll do the pretrial conference and try and clarify the issue for both parties before you proceed to trial, okay?
Sounds good.
Oops, I couldn't hear you.
Sounds good to me.
Okay, all right, thank you all.
Thank you, Your Honor.
Thank you. Okay, I'm just going to keep going in order of how old these cases are in our court system. Next, I have Kyle Weiss and Carissa Shoemate, along with Ms. Fellows. This is number 2 on the docket, 17-3-000-404.
Yes, Your Honor. Beth Fellows, GAL, present.
Good morning.
Morning.
Do I have Mr. Weiss? I think I saw you log on.
Yep.
Okay. And do I have Ms. Shoemate?
Yes.
Okay. I had you all on for pretrial management. I believe you all are still set for trial the week of October 9th. Is that correct?
Yes.
Okay. Ms. Shoemate, when we were last here for readiness, or excuse me, pretrial, you were unable to participate, is my understanding. And there was a discussion at that time about next time you were here confirming the issues for trial. anybody want to jump in?
Yes, Your Honor. This is the GAL. This was classified as a modification of a parenting plan. However, throughout the course of this case, there's never been a final parenting plan signed with the court and filed. So in reality, this needs to be reclassified as a trial for final parenting plan. And I wasn't sure if there could be an agreement to go ahead and just reclassify that, or if it needs to go back to the trial assignment docket.
I don't believe so. I think what my hope was is that with agreement of the parties, Mr. Weiss and Ms. Shoemate, there would be a record today on the clerk's minutes that you are both in agreement that the issue for trial is your final orders.
I'm in agreement with that, yes.
And Ms.
That's-
Shoemate,
I think that's what we agreed on for trial.
okay. And then Ms. Looney, is there any position from the state?
The state would be in agreement with that as well, Your Honor. We're ready to move forward with trial.
Okay. So Mr. Weiss and Ms. Shoemate, since you are unrepresented, this is pre-trial management. Do you both feel as though you're ready to proceed to trial the week of October 9th?
Yes.
Negative, Your Honor.
Why do you say negative?
Well, I was kind of hoping to get a copy of the GAL report so I can provide the proper paperwork to back up all the findings in it. And between today's date and October 9th, that's just not enough time to get it all together and get the other party served. I would like a copy of all the GAL information so that I can provide proper paperwork and get it served in a properly timed manner so I can get ready for trial.
And Your Honor, if I could address that.
Yes.
I have been working on the GAL report. Excuse me. And it has taken me longer. There's more details in it that I've had to add to it. My plan, and what I will do is I will file it before the end of the day tomorrow, Thursday, September 28th. And I will email both parties as well.
So I think Mr. Weiss, if that GAL report is to you by the end of the day tomorrow, at this point, I'm not going to strike trial for week of October 9th. You do all have trial readiness scheduled on October 3rd. So if you get the GAL report tomorrow and you feel like you still need additional time before trial, please let the court know on the October 3rd readiness docket. I guess my only, I can't give you legal advice, but I don't know what you mean by you have to serve it on other parties, because Ms. Shoemate is going to get a copy just like you are.
What I meant by serving is I need the documents to back everything that the GAL has said in her report that on my behalf. So, and I'm pretty sure I have to serve Ms. Shoemate with what I'm bringing to trial.
And this case has been going on for so long, even just in front of me, let alone a prior judicial officer, that I, at this point, have a hard time believing you wouldn't already have all that information. So I'm going to go ahead and keep trial for October 9th. Again, if you get the GAL report tomorrow and you still feel like you're not ready to move forward, we can address that at your October 3rd readiness hearing, okay?
Sounds good.
Okay. Anything else on this case?
I don't believe.
What time is the trial readiness, Your Honor?
Let's see, trial readiness is October 3rd at 11:30 via Zoom.
Okay, thank you.
Of course. Anything else? Okay. Yep. And I'm not going to set a review date on this case since you are going to trial. If for some reason it is struck at readiness, we'll get you back on this calendar and move forward.
Sounds good.
Okay, thank you both. We took care of number 3. So number